Shalom, this is your Ark. Yah is magnified. Coming back with another informative video. I titled this video, William Rigby, Federal Lawsuit. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All of my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, so now, as you all can see on the screen, this is another one of Charles' federal lawsuits. For those who do not know who Charles is Amen Osiris, the fraud of law. This is his client, federal lawsuit, okay? This client of his filed 2 federal lawsuit claims in federal court. He probably paid $800 to file both, okay? $400 per case, right? So we're going to go over this order. This order was filed this year. Okay, filed, so as you all can see, January the 30th, 2018, highlighted in blue. So we can all see that, hey, this is this year. So he filed this claim in the United States District Court for the Western District of Pennsylvania. Okay, as you can see, the plaintiff is William of the family Rigby, right? Amen Osiris, common thing, that's all he do. He do the same thing on every lawsuit. He doing the same thing. But let's continue. Teresa D. Miller, well, he verses Teresa D. Miller in her official capacity as Secretary of Pennsylvania Department of Health and Human Services, Customer Services. He also going against Robert Patrick Jr. in his official capacity as Director of the Pennsylvania 42 USC 654-3 Bureau of Child Support Enforcement. Also, he's going against Beth Shahini in her official capacity as Director of Washington County, Pennsylvania, Domestic Relations Section. Right? This is his first case he filed. As you can see, the case number is 17 CV 1415. This is his second case he filed now. 18 CV 0110. Okay? And in this case, you have the same plaintiff, William of the family Rigby, versus Pennsylvania 42 USC 654-3 Bureau of Child Support Enforcement et al. Defendant, right? So let's continue. Memorandum orders dismissing 2 complaints. So now, both of his clients' cases got dismissed in federal court. Like I tell y'all, man, I'm not here on YouTube to make y'all believe something ain't true. Hey, I put up evidence, facts, proof, and all types of information for you all get understanding of what's really going on. Y'all don't have to take my word for it. It's right here on the screen. The facts are going to be the facts and the truth going to be the truth, man. So now, this client filed 2 cases and both cases was dismissed. He lost 2 times in federal court dealing with Amen Osiris. But let's read over the memorandum. It says, 1. Introduction. Pro se plaintiff, who identifies himself as William of the family Rigby, has brought 2 separate lawsuits alleging civil rights violations and conspiracy against several alleged wrongdoers, namely family court / child support officials in Washington County, Pennsylvania, and Washington County as a whole. So now, like he sued in his last case that we're still going on, that's still pending, that I'm telling y'all he's going to lose as well, his client Daniel is going against Henry County. This client William is going against Washington County. Okay, so now let's finish reading. It says, among other officials, plaintiff complaints appear to focus on an appeal of child paternity and or child support ruling made in Washington County. In both lawsuits, plaintiff seeks $5,000 from each defendant. Well, $5,000 from each defendant, jointly and severally, plus punitive damages, costs, and equitable relief. Plaintiff appears to allege that the Bureau of Child Support Enforcement and the application of the 4D program somehow violates his rights, and on this basis, he brings a 10-count complaint in 17 CV 01415 and a 20-count complaint in 18 CV 00110 alleging numerous claims including conspiracy, involuntary servitude, and involuntary slavery. These claims are clearly fanciful, basically stating that fanciful means basically made up, something that has no backing, basically something just not true, But let's continue. Or frivolous and wholly without merit. And the court therefore dismisses both complaints. So both complaints got thrown out. But let's continue reading. Number 2 is case laws. Title 28 United States Code Section 1915A obligates the court to review a prisoner's complaint as soon as practicable after docketing, and to dismiss the action if at any time it appears inter alia that the action is frivolous, malicious, or fails to state a claim. Number 28, right? But let's continue. But let's pick this up at the bottom real quick. Let's read the footnotes. Number 1, plaintiffs have brought these lawsuits under a false or fictitious name, which the court may dismiss on this basis as well. So basically stating because he put of the family in the name, then the court can dismiss the case as well. Okay? Why? Because all claims must be brought in the true name of the party in interest, or in the real name of the party in interest, which he don't know and which he don't have an understanding of doing. But hey, that ain't on me for to teach him. I can't teach him certain things. The guy too hard-headed to listen to me. He'd rather proceed in his ignorance and take all his subscribers down in that same ignorance as well. But let's continue. Number 2, the court takes judicial notice that plaintiff appears to be referencing Title 4 of the Social Security Act, which relates to grants to the state for aid and services to needy families with children and for child welfare services. And specifically, Part D of the Title 4 relates to child support and establishment of paternity. Okay, now let's pick this back up. It says, United States Code 1915 AB1, it is important to note that Section 1915E2 is not limited to pro se prisoners' suits. Case law to back that up. Additionally, 28 U.S.C. subsection 1915E provides, notwithstanding any filing fee or any portion thereof that may have been paid, the court shall dismiss the case at any time if the court determines that A, the allegations of poverty is untrue, or B, the action or appeal 1 is frivolous or malicious, 2 fails to state a claim on which relief may be granted, or 3 seeks monetary relief against a defendant who is immune from such relief. So let's continue. The standard under which a district court may dismiss an action as frivolous under 28 U.S.C. subsection 1915D, the predecessor to section 1915E2, was clarified by the United States Supreme Court. Case law to back that up. Dismissal is appropriate both when the action is based on an indisputable meritless legal theory and when it posits factual contentions that are clearly baseless. So he's basically saying that his claim was baseless. It didn't have any type of standing to hold up in federal court. But let's continue. Where a complaint alleges facts that are clearly baseless, fanciful, which again means totally made up, or delusional, it may be dismissed as frivolous. So you have this guy putting in delusional claims in federal court. The judge is straight eating this man alive, but he called himself the undisputed fraud of law. Nah, man, you getting your butt kicked. You and your clients getting your butts kicked. But let's continue. If the pro se plaintiff can cure the factual allegations in order to state a claim, the court should grant him or her leave to do so. Case law to back that up. A determination of factual frivolousness is appropriate when the facts alleged rise to the level of the irrational or the wholly incredible, whether or not there are judicial noticeable facts available to contradict them. Case law to back that up. Now let's go over the conclusion. Number 3, conclusion. Having reviewed plaintiff pending claims as contained in the 2 recently filed complaints, the court finds that the allegations of these complaints are individually and collectively fanciful and frivolous, and no amendment will be permitted for the current complaint because no amendment could cure the deficiencies that require dismissals in these cases. So again, he can't even amend this complaint because the court basically don't really have jurisdiction to even hear the complaint. So why would they have him amend something that they can't even listen to from the beginning? But let's continue. Let's get to the meat and potatoes. Suit against a state agency. So again, if he's bringing that suit against, hold on, let's go back before we go in. He's bringing his suit against, again, Pennsylvania, 42 U.S.C. 654-3, Bureau of Child Support Enforcement. The court clearly letting you all know that it's a state agency. Let's pick it up right here. Not a federal agency, not a federal agency, or not a federal franchise doing business in the county like the fraud of law, like Charles wants y'all to believe. Nah, man, the guy's delusional. I keep telling y'all, the guy is a nut job. He lost his marbles. But let's continue reading. It says suits against a state agency or a state department are considered to be suits against a state which are barred by the 11th Amendment. Now I told y'all, man, the state and his agencies all have immunity, right, in federal court. If you're suing the agency, it's like suing the state. Why? Because the agency is a creation of the state, and they both are immune underneath the 11th Amendment. Hey, I ain't make this stuff up. That's their laws, their codes, their rules. This stuff they made up. I'm just here giving it to y'all like it's supposed to be given to y'all with the facts. That's it. That's all. But let's continue. It says the 11th Amendment applies to suits against subunits of the state and suits against state officials for acts taken in their official capacity must be treated as suits against the state. So if you're bringing suits against all those people in their official capacity, you're still bringing suits against the state. Because you're bringing suits against the state, they fall into sovereign immunity as well in federal court. Hey, I've been telling y'all this for a minute, man. But I'm just the messenger. Don't shoot the messenger, man. All praise and honor go to the Most High, y'all, man. That's all I got to say. But let's continue. The Commonwealth of Pennsylvania vest judicial powers in a unified judicial system, and all courts and agencies of that system are part of the Commonwealth government rather than local entities. So again, they are state agencies. Hey, don't take my word for it though. The judge is breaking it down and getting no clearer than this. But let's continue. And PA Constitution, Article 5, Section 1, it likewise is settled that Pennsylvania judicial districts are entitled to 11th Amendment immunity. The District Relations Section is a subunit of the Washington County Court of Common Pleas, and thus it is a subunit of the Commonwealth Unified Judicial System. See 42 PA CSA Section 961. Each Court of Common Pleas shall have a domestic relations section, according to Chilott versus Erie County Domestic Relations. So that's again another case law to back it up. Furthermore, the district court properly dismissed the suit against the Erie County Prison and the Erie County Domestic Relations section of Erie County Courts of Common Pleas because the 11th Amendment of the United States Constitution protects an unconsenting state or state agency from a suit brought in federal court by one of its own citizens. Again, same thing. Let's continue. The Washington County Domestic Relations Section and its employees, while working in their official capacity, is a subunit of Washington County Court of Common Pleas. Immunity attached to the actions of the Washington County Domestic Relations Section and its employees pursuant to the 11th Amendment. Accordingly, plaintiff claims against these individuals and entities must be dismissed. Another case law to back it up. Again, I cannot stress this enough. Stay out of these federal courts. Proof is in the pudding, but let's continue. The state courts of Pennsylvania, including their domestic relations sections, are entitled to immunity from suit in federal court pursuant to the 11th Amendment. See also, case law to back that up. Let's continue. The protection of judicial immunity extends to those officers who perform quasi-judicial functions. Let's continue. Additionally, to the extent that plaintiff is attempting to appeal the judgment of the Washington County Domestic Relations Section, although he claims that this is not a complaint about paying child support, the court may abstain under Younger versus Harris, another case law. and or the Rooker-Feldman doctrine. Here we go again with the Rooker-Feldman doctrine. Same thing I've been telling y'all. Check out my old videos or other guys' cases. I've been telling y'all the same thing. But let's continue. Under the Rooker-Feldman, the court lacks jurisdiction when entertaining a federal court claim would be the equivalent of an appellate review of a state court judgment. Focus versus Allegheny County Court of Common Pleas. Let's continue. Case law to back that up. Here, it appears that if this court were to entertain the claims of the plaintiff herein, the court would be essentially exercising an impermissible appellate review of the support orders of the Washington County Domestic Relations Courts and would effectively be required to void the state court ruling, or if there is an ongoing judicial proceeding, as in Younger, the court would abstain from hearing these cases under Younger as well, because plaintiff does not specifically reference the procedural postures of the state court proceedings. The court is unable to determine which abstention principles is applicable here. Accordingly, the court hereby dismissed the complaint at docket numbers 17 CV 1415 and 18 CV 110 as frivolous and as without merit, because this court lacks jurisdiction and because defendants are immune from suit. Leave to amend is denied as futile. The clerk of the court shall therefore mark this docket closed. So ordered this 30th day of January 2018. So again, stay out of these federal courts, man. Stop letting that guy deceive y'all. Amen Osiris, Charles, he's a complete scam artist. He's a fraud, man. I'm exposing him back to back. I see why he hate me so much. But hey, buddy, you bought this on yourself. I told you, man. Keep my name out your mouth, because I'm going to embarrass you. So again, another one of his clients bites the dust. Another one bites the dust. Don't. Another one bites the dust. Sorry now, but all jokes aside, man, stay out of these federal courts. That's all I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Continue to fight. Don't quit. Don't give up. Like and subscribe. Hit the notification button so you all can get information when I provide these informative videos. Continue bringing the proof. Continue bringing the truth. I'm never going to stop. So again, if you need my help to seek remedy, hit me up at y'allismagnified@gmail.com. Continue to fight for all my brothers out there fighting. I'd like to thank all my subscribers for watching, and all those who've been down with me from day one, and for all those who can hear this truth, see this truth, and recognize this truth. Because all glory and honor go to the Most High Yah. So with that being said, you all be blessed. I'm out. Shalom.